Mr. Abiodun Jelili Owonikoko, Senior Advocate of Nigeria, is hopefully still here with us. Good morning, Mr. Owonikoko. Are you there?
Good morning. Can you hear us now?
Good morning.
Brilliant. Oh, excellent. We can hear you loud and clear.
I can, yes.
Yes, thank you very much for joining us this morning, Mr. Owonikoko. Let me ask you to enlighten us on the matter of the Executive Order number 10, which President Buhari signed on May 22nd to give effect to Section 121, subsection 3 of the 1999 Constitution as amended with regard to monies due to state houses of assembly and judiciary. Now, is an executive order constitutional? Is it legal? Can an executive order be used as an instrument of lawmaking, as seems to have been the case with executive orders under this administration? And what is likely to be the effect of this executive order number 10, as it is called?
Thank you very much. The Constitution of Nigeria has divided executive, legislative, and judicial authorities among three different arms of government. Section 4 confers legislative powers, Section 5, executive, and Section 6, judicial powers. All of these have to have ways and means to discharge their functions, and that's why we have provisions for revenue, mobilization, and allocation. The powers of the executive are limited only to executing laws, either laws contained in the Constitution or in legislations, whether principal legislation or subsidiary legislation. The instrument of executive order is not a legal instrument because laws in Nigeria are in hierarchies, starting with the Constitution that is the supreme, the statutory enactment, then you have the bylaws and regulations, bylaws for the lowest tier of government. Executive order is an instrument of clarification to operatives under the executive in order to better discharge their statutory functions, because you use executive orders to execute public power, not private power. And public power derives from enactment. That said, by convention of presidential system, it has been an instrument that has come to good use, even in the US, over time. Often, whenever the law is not too clear and the implementers may have need for clarification, the chief executive, usually either the governor at the state level or the president, then issues this guideline or directive that operators of the law will guide themselves better to implement. So it is not law. The first problem with that instrument is that it used the language that the president has enacted the law by way of executive order. That will be the first challenge under the principle of quo warranto, that what authority has a president to enact a law? Two, the executive order has not added or created any new right and obligation. What it has done is to duplicate and exemplify what has already been enacted into the Constitution. Now, mind you, the fourth alteration to the Constitution Act number 4 of 2017, which became operative in May 2018, was not a law made by National Assembly. People are getting it wrong. It was a law made by National Assembly and State House of Assembly, because it was an amending provision of the Constitution. National Assembly alone cannot amend the Constitution. All 36 states have to concur. And it's after that concurrence that the president assents. So it's not one of the laws that the president can say, as the head of the executive branch at the federal level, he was implementing a federal enactment. The Constitution is binding on all authorities, including even non-governmental, including myself and your good selves. So the limit of the presidential power to execute law has to do with laws made by the federal government for federal governance. And the Constitution has divided our government into three tiers. None of them can usurp the function of the other. That said, I now go to the executive order itself. There is a fundamental flaw in the way it was conceived, which is that The order has given directive to the Accountant General of the Federation to act in line with it or with further directive given by the Attorney General of the Federation, commanding state authorities, which will include even the legislature and the operatives of the executive arm, to submit their budget to the Accountant General of the Federation for the purpose of ensuring that appropriations or funds charged to the consolidated revenue of the state meant for the executive, for the judiciary and legislature are provided for, and if they are not provided, then the federal government can withhold and directly disburse. This is totally unconstitutional. That's because Section 153 of the Constitution has provided certain bodies called executive bodies, one of which include the Revenue Mobilization, Allocation and Fiscal Commission, that is charged with the duty of allocating revenue from the Federation account. Once that is done, FAC, which is the Federal Allocation Committee, in which state commissioners of finance and accountant general of the state also participate, then meet and decide on how much of this fund go to the state based on the revenue allocation formula. Once that is done, what you are doing is allocation of revenue. It's not appropriation. And it's after allocation that the consolidated revenue of the state can be determined, which will include not only federal disbursement, which is a receipt. It also includes revenue raised by the state, which is what we call IGR, internally generated revenues. It is a combination of both that constitutes the consolidated revenue of a state. At that stage, under Section 121, it is the authority of the state, executive and the Auditor General of the state, to apportion and submit a budget by the governor to the state house for appropriation. What is now being directed by the executive order is for them to submit proposals, which is what at the state federal level is called budget call circular, where you submit what you propose to spend in the coming year. For those who are preparing budget, then when we do that, we are converting the country into a unitary state where state government, after receiving their fund and generating their fund, they will now submit it to a federal agency or authority to vet and then disburse to whoever they win. Now that already infracts from the power of appropriation, power of the purse of the National State Assembly. It also detracts from the power of the governor to prepare a budget. And also, who then vets, evaluates, and determines priorities under that provision? The federal government has its own Fiscal Responsibility Act. Some states have their own fiscal responsibility laws, which governs how monies are disbursed on an annual basis over a period of time. That's why even when the Fiscal Responsibility Act was enacted, it did not go as far as imposing obligations on states. It only entreated their cooperation, because they know that once monies are allocated to states, it is no longer the business of federal government to dictate to them or second-guess how it is spent. So, final point is that even under Section 158 of the Constitution, the body charged with allocating revenue is an independent body that does not listen or take directive from the president. It is meant to be an independent body of the executive, just like INEC. So, for the presidency to now issue a guideline directing Auditor General and Attorney General to, as it were, hijack functions of the State House of Assembly and then dictate how their priorities for economic provisions are made is totally unconstitutional. Beyond that, there is a provision in the Constitution that says where these bodies that are charged with allocating revenue have reason to impose obligation on state authorities, they must get the consent of a state governor. So, how then, so what the discretion that the president has exercised now actually belongs to the state governors, which a responsible state governor would not lightly ignore, knowing that it's now a constitutional provision that you must directly disburse portions of your country revenue that is meant for parliament and for the judiciary. That step has not been taken. And I've read that the governor actually were meeting and they were interacting with the federal government to work out a modality like a kind of compromise which they would not be able to resile from once they agree. But it's not for the president to preempt them and then impose his will. So this is where we have challenge with this executive order.
They were in talks, and it took them by shock that this executive order therefore came out. But Mr. Owonikoko, let me get your reaction to a reaction from another senior advocate of Nigeria, Mr. Abiodun, who came out to urge the president to actually go further. And he said the president should go further and grant total autonomy to the judiciary by signing another executive order to implement all parastatals, agencies and departments of government to implement Section 287 of the 1999 Constitution by complying with all orders, judgments and decisions of the courts. What is your take on this?
Well, that exactly demonstrates the true validity and relevance of executive order. It ought not to require an exhortation from the president for any government functionary to comply with the judicial pronouncement. Because under the Constitution, all authorities are bound to implement judgments of court. Not just court, not just lower court, all authorities and persons. And if there was any confusion about this before now, that is a welcome development. That conflicts with nothing. I've just told you now that there are provisions of the Constitution that are self-executing. There are others that need certain action to be taken for their execution. This is one such provision, which is already a clear command, and where you see an infraction, it is no longer necessary for the judiciary to go about and execute their judgments. It is the function of the executive to execute judgment of the judiciary. So where that is not being complied with, it is appropriate for Mr. President to issue guidelines to govern how functionaries of government treat judicial pronouncement. I think that is welcome. That's the difference. That you can see that's not a direction to an arm of government or to a tower of government to walk to the orders and direction of another tower of government. That is something that is welcome. The real challenge is the one commanding state to submit funds within their own control, their revenue, their power of the purse, submit it to a functionary of the federal executive to dictate how it is to be disbursed. And the Constitution did not say that the federal government should channel funds meant for legislature or judiciary to those functional, to arm of government. He said it is a command on the governor of the state and his functionary. So the president cannot take over the function of the governor of the state to do that. Let me be clear. It's not as if this law, which is welcome and is commendable, there's the fiscal autonomy amendment to the Constitution in 2018, is not desirable. It is desirable. In fact, the difference between that and what used to be was that that same provision was there for the judiciary, but it was not extended to the legislature. What they did by the amendment is simply to now include funds meant for the legislature to be among those that are going to be first-line charge on the consolidated revenue. So one would expect that given that there is now the constitutional teeth for enforcement, it doesn't require a presidential executive order. In fact, the Attorney General of the Federation, as the chief law officer, can actually proceed against a state government that continues to act in defiance of Section 121(3) as amended. Even public interest litigators, as happened under the Constitution before its amendment, in the judgment delivered by Justice Ademola of the Federal High Court, confirming the financial autonomy of judicial arm of government, can also litigate. In fact, proactive litigation by federal AG is more appropriate in the circumstance than to issue illegal and unconstitutional presidential order, which also has this tendency to create what I call headmaster presidency. We don't seem to respect each tier of government as an independent arm, as decided by the Supreme Court in AG Bendel and AG Federation in 1982, almost 38 years ago. Why are we revisiting and reopening settled issues? Well, so it is my suggestion that even an Auditor General or Accountant General that refuses to disburse that money will be committing financial misappropriation, which is also a criminal offense under Fiscal Responsibility Act and law that EFCC can proceed against. So if you can't go against the governor because of his immunity, the governor doesn't sign checks. People should know that. He does not disburse fund. He only authorizes. The functionary of government that does that is the Accountant General of the state. And you can proceed against him if at the end of every year there is an audit that shows that funds meant for these two arms were not disbursed. You can actually prosecute the Accountant General of the state in respect of that. And that will act as sufficient deterrent rather than us embarking on a lawful mechanism to give teeth to the constitutional provision. So there are many options that are legitimate that we can explore as against this.
Well, Mr. Owonikoko, very well said. Executive Order number 10, if I understand you correctly, as phrased, is a short step to dictatorship, usurpation of power, of the doctrine of the separation of powers. And the president is quoting Section 5 as the basis for his action. But the governors, too, are also quoting the same Section 5, subsection 2 thereof. And they're saying that this, what has been done is unacceptable to them. Now, what advice will you give the state governors? Should they go to court so that the court of law can help clarify and resolve what appears to be a kind of simmering conflict?
Well, in a democratic and constitutional society, the most responsible recourse for resolution of dispute between government authorities is the court. That's why the judiciary is set up as the third arm of government. It's supposed to be independent. Now, a dispute of this nature actually is a state and interstate dispute. That is state and federal government dispute. And it does not originate at state high court, federal high court, or court of appeal. It's supposed to be used to activate the original jurisdiction of the Supreme Court. So my suggestion and advice is for the state to proceed to Supreme Court to test the legality of the Executive Order number 10. And you can see that it's going to be a fast-paced judicial process. That said, Section 5 of the Constitution, like I said, prescribe authorities of executive arm of government, both at the federal and state. There are areas of overlap which have to do with concurrent legislative lists. We have federal government as preempted states. Disbursement of revenue that is in the concerned revenue of a state is not within the powers of the federal government to interfere or manage. And we are undermining authority of the state by making them look like schoolboys who needs to be shepherded by a guardian as a president. Why is it that each governor has to go to the election for his own money, the same way the president goes? After the election, each governor assumed the full plenitude of powers conferred on him under Section 5. And some of those powers are not necessarily in state laws. They are embedded in the Constitution and entrenched to separate the limit of the power of the president from that of the state. But where there are overlaps, state must kowtow to federal directive. In this case, with regards to revenue of the state, the federal government has no control whatsoever. They can only cooperate and work out working modality with state government if they have priority projects that they want each party. And that's why you see, even when we had this Paris debt refund and the rest, and they wanted to make some commitment of funds for certain projects, they need to get the consent of the state government. A state government is made up of the judiciary as well as the legislature. But it's only the executive arm that we're always looking at. And I wish to pose this question, if you have a legislature in the state that is supposed to act as check on the governor, including power to even remove a governor, why do they need a president to come to their aid to exercise power that the Constitution has already vested in them? Their right to have their own revenue disbursed to them. Why do they need a president to do that? It shows that its parliament at the state level are themselves their own enemies. They have powers, they don't know how to use it. They are asking a third party to come out. And once you do that, once you inexorably submit your authority to a third party, you are gradually undermining your authority. I don't think that any self-respecting parliament that is out to do its job, fully cognizant of his powers, will require a president to assist him with ordinary executive order to enjoy the benefit of a constitutionally entrenched provision guaranteeing their right to have disbursed to them their share of state revenue. Something has to be wrong if that is all they require for them to enjoy their autonomy.
Thank you very much,
Thank you very much,
SAN, for this very illuminating commentary and observations. Thank you very much.
Thank you.
We appreciate your joining us this morning.
My pleasure.
Thank you.
Eid Mubarak to Nigerians. Today is Eid holiday.
Okay,
yes.
Thank God for making us see the Ramadan for this year.
Yeah.
Thank you so much.
Enjoy your day.
Thank you.
My pleasure.